Commissioner of Correction versus Worcester County Superior Court.
Mr. Saltzman.
Good morning. May it please the Court, I'm William Saltzman. I represent the Commissioner of Correction, who is the petitioner appellant. The Commissioner respectfully requests that this Court exercise its authority under Chapter 211, Section 3 to correct a substantial error by the lower court where the Commissioner has no other available, no other practical avenue for review. By ordering a wide-scale relocation of pretrial detainees from county custody to state custody, the Superior Court, in effect, rewrote Chapter 276, Section 52A to achieve a result that was never intended by the legislature, that is contrary to the plain meaning of the statute, that's contrary to the legislative history of the statute, that is contrary to the long and consistent interpretation and utilization of the statute by the public officials who implement its provisions, and it is also contrary to the way the statute has been viewed by courts in county conditions litigation.
Can I ask you this very practical question? What's behind the story here? I mean, the statute obviously also encourages cooperation amongst these various officials and permits prisoners who are awaiting trial who have previously served time within the Department of Corrections to be transferred to a Department of Corrections facility with the consent of the parties. Is this a result of a communication or an effort that simply broke down?
No.
Beds. It's beds, right? Shortage of beds.
Well, there's nothing on the record really indicating...
well, the judge said so. I mean, that's the... I don't know what the judge had in front of him, but the judge said it's beds.
And beds is an issue on both sides. But
no, I understand that, but I think your point is it doesn't,
No, my question is a little different. I mean, my question is this. Before the judge issued this order, which directed the department to accept prisoners and to move them into state facilities, had there been a request of the commissioner that had been turned down? Had there been some sort of interaction that sort of set the stage for this?
There's nothing on the record that indicates the prior history, but it's my understanding that there may have been a request made by the sheriff. The commissioner is accorded discretion to make the determination on a case-by-case basis whether to accept eligible pretrial detainees into state custody. The commissioner declined the request. It appears that the sheriff then, through the district attorney, went to the Superior Court and urged a reading of Section 52A that is entirely contrary to the...
And I take it the department was not made a party to that proceeding?
The department found out about it when the faxed order came through. I appeared in court the next day before Judge McCann to argue that he lacked the authority to transfer the pretrial detainees absent the consent of the Commissioner of Correction.
And I take it that this was an order directing the department to accept an unknown... this wasn't an order that came out of a particular case where the department was being...
There was a list of people, though, wasn't it?
There was an original list of 51 names. The names of the individuals, their identification numbers, were appended to the petition that the district attorney provided to the Superior Court.
All right, but I guess my question was, and I'm sorry if I didn't really phrase it correctly, this was not in the context of the Superior Court judge having set bail and then directing that this person be rendered to the custody of the Department of Corrections.
No, it was done en masse.
En masse, just a large...
It was done by an ex parte administrative order.
Yes. Yes.
Could I ask you to comment about the fact that the legislature used the word prisoner in Section 103 of Chapter 127 and then sentenced prisoner in Section 104? And the same difference, as I see it, is in Section 105 and 106. And I wonder if that would indicate that the legislature uses the word, at least sometimes, prisoner, to mean a pretrial detainee, and And if that could be what is meant by the use of the word prisoner in 276, Section 52A.
The 103, 104 are archaic statutes. They were superseded by Section 97 of Chapter 127. At the time those sections were in effect, my understanding is that all these removals involved removals of sentenced prisoners. It's because there was no effective means to remove detainees that the legislature enacted Section 52A in 1943. But Sections 102, 104, these old sections are now incorporated within Section 97 of Chapter 127, and all of the provisions in Section 97 pertain to sentenced prisoners. By statute, the word prisoner is broadly defined. It's anyone, if I may paraphrase, it's a committed offender or anyone else placed in a correctional facility by law. So,
including persons held in jail for trial?
Yes, it's a very broad statute.
What are the practical consequences of this order on the Commissioner?
Well, the practical consequences are that the Commissioner now has an additional 60 persons whom the Commissioner should not have. They are pretrial detainees, which pose an extreme burden in that they need to be transported back to court frequently. Aren't
they also entitled to certain privileges that a sentenced person is not entitled to?
Don't you have to be kept separately and so on?
Well, there are many aspects that make it a difficult problem. Transportation certainly is one of them. Because the department is comprised of numerous facilities of various levels of security, these individuals are necessarily classified and placed throughout the system. In some instances, the department may have to transport individuals all the way from Plymouth County to Worcester County. So it has imposed a tremendous
And I suppose
burden.
another downside from your point of view would be that if we uphold the Judge McCann, other Superior Court judges in similar situations or other situations, maybe not so similar, could say, I'm issuing similar order, I'm going to issue the same order.
I have no doubt that every other sheriff is looking at this case with great interest.
Could the Commissioner take one of these 51 pretrial detainees and send them to a different house of correction?
I'm not sure.
Without a court order,
We
without
do-
the
we-
agreement of the sheriff?
We do have the court order that the Commissioner is following. The court order instructs the Commissioner to accept and hold these individuals in state custody. I don't think that would be practical. I actually don't think it would be fair to the other sheriffs for the Commissioner to start dispersing these individuals off to other counties.
But it's not clear to me that under the statute the Commissioner would have that authority absent either another court order, amended court order, or the agreement of some other sheriff, the sheriff of Essex County or the sheriff of Middlesex County or the sheriff of Suffolk County or any other county.
Yeah, typically, when someone comes from county custody to state custody to await trial, it's by permission of the Commissioner. The Commissioner, in that case, where there's no court order, can hold the individual as long as she sees fit, and at such time as she sees fit, she may return the individual, or she shall return the individual when the DA so requests, so the individual will be returned to the county to appear for trial.
Can she hold that kind of a pretrial detainee in that kind of a situation in a different house of correction?
I'm not sure.
You mean,
Actually, I'm not sure I understand the question. If the individual's been transferred to the department's custody,
Yeah.
can the Commissioner then turn the person over to another county?
Like Hamden, for example.
Where there might be room.
Aren't the sheriffs in charge of those houses of detention? Can the Commissioner override them?
No. Again, because the statute has been...
No, he can't override them?
the Commissioner can't override a sheriff?
Of a different county from the one.
I mean, suppose there's room in Hamden for these people, and the Commissioner finds out about that and calls up Sheriff Ash, and Ash says, yeah, but I've got my reasons why I don't want to allocate that space at this time, so the answer most respectfully is no. Can the Commissioner say to Sheriff Ash, you've got to take these people?
I don't think that's contemplated by the trial. I think, by the statute, excuse me. I think the problem here is that because the court has acted outside the scope of the statute, it creates a situation that might suggest a remedy, but really isn't practical, more consistent with...
I guess we're asking, are there other statutes or regulations apart from this statute that would permit the commissioner to do it? Does he have some kind of supervisory power over the sheriffs?
I can't think of a statute that would permit the commissioner to take one of the individuals who is waiting trial by court order from Worcester County and send that
But
person.
I take it, the Superior Court can order a county-to-county transfer. If the
Yes.
answer to a
That's
problem
right.
is there's beds in Hamden but not in Worcester,
That's right.
and
Exactly.
even if the Hamden sheriff says no, what the statute seems to contemplate is that's when a Superior Court judge can get involved
Right.
and can order Hamden to accept it.
That's exactly right.
Okay, so it doesn't even go through, it never, if that's what's going on, it never goes through the commissioner in the first place. The
Well,
commissioner doesn't do it.
except the commissioner is the one responsible for removing the prisoner from one county jail to the next, under the statute.
Yes,
And
but
in the
the-
scenario that Justice Osmond was suggesting, it is still the commissioner of correction that takes custody of the individual and transports them?
That's what the statute provides. The commissioner does not initiate a county-to-county removal. The commissioner has no statutory role until the district attorney
Does
or
the-
the court.
Does the commissioner, as a matter of course, apart from this case, actually have facilities or space for pretrial detainees?
Well, I'd be drifting outside the record.
Okay.
The
If it's
commissioner
not in the record, then-
holds a certain number of individuals who are pretrial detainees. There are many women who are pretrial detainees who are at the awaiting trial unit in MCI Framingham pursuant to Chapter 125, Section 16, which is a statute in which the
little bit different.
legislature has indicated that people should be transferred en masse if there's no available beds in the counties for females. This is a very different situation, and in getting back to it, there is no authority under the statute for what the Superior Court did in this case. The reading that the court accorded the statute just cannot stand up against common and accepted principles of statutory construction.
So this order, if it doesn't, in fact, I don't know whether the record reflects it or not, it either in fact or potentially could interfere with the commissioner's ability to handle the statewide prison population and where to shift people around within the state prisons, prisoners that are under sentence to the commissioner.
Absolutely, and in fact, our affidavits were filed to demonstrate that this order could not have come at a worse time for the department, in that we had shut down the departmental disciplinary unit, which required relocation of the most dangerous inmates into segregation units in other facilities, and necessitated that we have other beds available to move people around when required. So right now, it's not a good situation for the commissioner. Potentially, it's even a worse situation were the statute to be held to authorize any superior court to
Do this.
order an exodus of pretrial detainees into state custody. But that can't be what the legislature intended. It's inconsistent with the history. It's inconsistent with the words. It's inconsistent with common sense that people who are awaiting trial should be held in state custody where there's no particular security reason for the person to be sent there. Initially,
Mr.
in 19...
Saltzman, may I ask you this? You made reference to a statute about where the legislature has provided for the, in your words, wholesale transfer of women prisoners to Framingham. What's that statute?
I referenced Chapter 125, Section 16, in response to the question about
Okay.
pretrial
I don't see
detainees
any
being-
reference to 125, Section 16 in your brief.
No,
Am I
it's not
correct?
in the brief.
It would seem to me that if the legislature has provided for this in one set of circumstances and hasn't provided for, isn't that directly relevant to how we interpret the statute?
Absolutely, and certainly within the statute itself,
But you haven't argued that point. You haven't argued that point.
No, I didn't. No, I didn't.
And I
But-
would also ask Mr. Saltzman, there's a requirement that we attach statutes to the back of the brief, so could you do that in the future? Because it's very
Yes, Your Honor.
helpful to have
Yes, Your
the
Honor.
rules complied with. And what exactly does that provide?
Excuse me.
125, Section 16, what does it provide?
The third paragraph says the department shall maintain at the Massachusetts Correctional Institution, Framingham, a separate awaiting trial unit for females, to which female prisoners held for trial in accordance with Section 42 of Chapter 276 may be transferred by the sheriff on approval of the Commissioner of Correction if suitable facilities are not available in the county jail of the Court of Jurisdiction.
So the judge, under that, the judge still would not have
No.
permission to order it?
It's interesting for comparison's sake, but it's
Okay.
not
But
particularly relevant
the
to the
legislature
situation.
hasn't in any circumstances, according to you, provided that a judge can order the commissioner.
None whatsoever, Your
Okay.
Honor. Thank you very much.
Thank you, Mr. Saltzman. Ms. Lazar-Moore?
Good morning. Ellen Lazar-Moore for the District Attorney for the Middle District. Judge McCann properly ordered the Commissioner of Correction to remove pretrial detainees from the Worcester County House of Correction to state correctional facilities because he correctly determined that Chapter 276, Section 52A authorized him to do so. When the statute is read as a whole, rather than parsed and analyzed as 4 separate sentences, it sets forth a scheme under which a judge may order the Commissioner to transfer a pretrial detainee to another jail with no conditions or to a state facility if certain conditions are met.
Ms. Lazar-Moore, don't we look first at the language, and if the language is clear of a particular sentence, you don't have to read the statute as a whole?
I believe that in any case, the statute is always read as a whole. If the statutory language is clear and not ambiguous, then the court will stop there in its analysis and not look to extrinsic evidence of the meaning of the statute. But in all cases, the statute should certainly be read as a whole and not parsed.
Well, in the first sentence, it says, specifies the circumstances in which persons held in jail for trial shall, by order of the justice, be removed. And the second sentence doesn't have any such provision.
No, it doesn't, Your Honor. But first, when the statute is read as a whole, Judge McCann's interpretation is supported by the language of the statute, in which the second sentence begins with the words "in addition," suggesting that it's describing one continuous scheme following from the first sentence.
But
why does
sentence 2 repeats
Yeah.
portions of sentence 1. I mean, your interpretation, if sentence 2 only included items that were new and different, I could maybe understand your argument that, well, you incorporate everything that's still in sentence 1, and this is just a new wrinkle. But there's some things in sentence 1 that are repeated in sentence 2.
Yes, Your Honor.
And therefore, it seems to me, if anything isn't repeated in sentence 2, we should assume it's not supposed to be there.
Well, Your Honor, I think
That seems to be the more normal way to, yes, you read them together, but even reading them together, seems to me, suggests that the court has authority to order county to county. That's explicitly stated, but that's missing from the critical sentence we're dealing with here.
it is, Your Honor. But if you look at the legislative history which surrounds the 1973 amendment to the statute, which added the phrase "and shall by order of a justice of the Superior Court," this strongly supports Judge McCann's reading of the statute. The amendment was initiated by a petition for legislation to permit pretrial detainees to be removed to a jail in another county by order of a justice of the Superior Court.
Right.
Following that petition, the House of Representatives proposed a bill entitled "An Act Relative to Incarcerating Certain Persons Awaiting Trial in State Correction Facilities." What the legislature ultimately enacted was an act providing that persons held in jail for trial shall be removed to another correctional facility
Right. So
upon
there's
an
a
order of the
compromise.
Superior Court.
There's a compromise.
Well,
There's a-
no, but
Accomplishing
it's an
both.
indication.
It involves the Superior Court, county to county. It also makes a provision for holding pretrial detainees.
It does, Your Honor, but if you listen to the language, it's an act providing that persons held in jail for trial shall be removed to another correctional facility upon an order of the Superior Court. So the legislature rejected a proposal to limit the judge's power to ordering a detainee transferred only to a jail, as was suggested in the initial petition, and also rejected...
I thought the initial petition was as follows. As I understand the legislative history, first, county to county, everybody's upset because sometimes the sheriffs don't agree, and to go back to Justice Glaney's thing, you have overcrowding in Middlesex and empty beds in Essex, and you can't get the sheriff of Middlesex to agree with the sheriff of Essex County, hypothetically. I'm talking about when the statute was amended. And so there's a bill filed to say, in certain circumstances, a court can order that, correct? Then there's a bill filed to say, well, if we're going to do it from county to county, why don't we do it from state prisons, to House of Corrections, County House of Corrections? And there's a compromise. There's a compromise. Not clear, by the way, before that, I take this is before 127, Section 16, that can be done by agreement. So the legislature says, okay, county to county, you can do it by agreement. If the sheriffs can't agree, the judge can order. We're now saying it's okay for the sheriff and the commissioner to agree. It's okay to hold a person held in jail for trial in a state prison.
In certain circumstances, as long as that person's got a felony conviction, previously served a sentence.
That second sentence was inserted in 1971. The initial enactment in 1943 provided for holding a pretrial detainee, the commissioner removing a pretrial detainee from one jail to another. The second sentence, which allowed the pretrial detainee to be held in state prison, assuming that he or she had had a prior felony conviction and served prison time, was inserted in 1971.
Right.
1970.
Go ahead, I'm sorry.
1973 was the amendment adding the language allowing a justice of the Superior Court to make the order.
Correct.
Now, there's no legislative history regarding why that language was proposed, but what we do know is that the initial petition was only proposing that the justice be permitted to make an order to remove the person to a jail in another county. That was the initial petition. The House then proposed a bill only stating that the judge would be able to order the person to be removed to a state correction facility. And what the legislature ultimately enacted was a judge being permitted to make an order to remove the person to another correctional facility. So, in effect, the legislature rejected proposals limiting the judge.
That's a big
titles.
It is in the title, and while
my question was about to be, if this was added in 1973, to your knowledge, has any other Superior Court judge in the intervening 32, 33 years ordered such a thing?
There is nothing in the record, and I am told anecdotally of one case in which it was done, but then the commissioner later agreed to the transfers. So
wouldn't it make sense, though, to say the first sentence, the legislature did it because, well, there are these disagreements, some would call them feuds, between sheriffs. So we need to do this sort of thing, let the judge do it. But then when you get to the state level, it's an entirely different proposition. You've got the state prisons perennially overcrowded. He described when this happened, a very bad situation, apparently. So the legislature would say, well, gee whiz, at that point, we ought to let the Commissioner of Correction decide whether he can do this or not. Doesn't that make sense?
Actually, I don't believe it does, Your Honor, with all due respect. I think that it certainly is clear that most, if not all, of the jails and houses of correction are also overcrowded, and no one would dispute that under this statute, a judge can order any number of pretrial detainees to go from one jail to another.
And even though Mr. Saltzman says he doesn't rely on it, this statute pertaining to the women in Framingham seems to support his position. Here the legislature has enacted a specific thing saying when the commissioner's got to take...
has an obligation, has any obligation.
Yeah.
Has any obligation.
He has to maintain this unit.
Has to maintain a specific unit at Framingham for...
It's stated differently. As a general statement, state prisons don't become part of the criminal justice system until somebody's been sentenced, correct? Except the legislature said there's one exception.
Women.
We've got one state prison. I think we still have one state prison for women, correct?
Yes.
And we have county houses of correction that may not have adequate facilities, so we're going to direct the commissioner to maintain a unit so that if it's not possible in some circumstances, you can take a pretrial. You have some obligation to keep some facilities.
Yes, Your Honor.
And
if I could
we
first...
will fund you, correct? We, the state legislature, will presumably have to fund that.
Well, first, again, Mr. Saltzman did not raise that argument, so I'm not completely prepared to answer it, but I will say that that's really just speculating about why the legislature enacted that.
Now that we've come across the statute, I'll leave it up to you people, but it might be appropriate for both of you to send in a 16L letter stating your positions on how that statute plays into this. Think about it. You don't have to.
Yes, Your Honor. But again, it's number one, that's pure speculation about why the legislature enacted a certain statute and did not enact a comparable statute regarding males. It's not the district attorney's position that Section 52A was enacted for the purpose of alleviating overcrowding, which seems to be the purpose of this. However, there's no question that in this instance, and in other instances involving Middlesex and Suffolk counties, that is how Section 52A is used at times. Going back to Justice Granier's earlier question, while issues of overcrowding certainly affect both the counties and the state, no one would dispute that under the statute, a judge could order any number of pretrial detainees to be transferred from one house of correction to another, regardless of issues of overcrowding, because the legislature allows it.
But, I mean, let's be practical as to how the statute ought to be used, should be used, could be used. If someone came in and asked the Superior Court judge to send 25 prisoners to a house of corrections that was totally overcrowded, there would have to be a pretty compelling reason for that to happen. I mean, a pretty compelling reason. A judge is just not going to send people from one jail that's not overcrowded to a jail that's overcrowded. I mean, that's just not, as a practical matter, not going to happen. But think about what your interpretation of the statute would do to our state correctional system. Wouldn't it wreak havoc? Literally, if every Superior Court judge decided, or every sheriff and every district attorney decided they'd like fewer prisoners in their little operation, just go and get a Superior Court to order another 50 prisoners over to the state. They've got a big system. They can figure it out.
Well, certainly, Your Honor, these are considerations to be taken into account by a judge in determining whether to exercise his or her discretion to issue the order.
Did the judge even have the Department of Corrections in when he made this order?
Not when he made the order, but the very next day the commissioner files a motion to vacate, and this was fully litigated in the Superior Court through motions to vacate, oppositions, motions for reconsideration, and oppositions.
Could I just ask you this? I know this is an administrative order, and the statute doesn't say so specifically, but to go back even to the first sentence, wouldn't it be a bit extraordinary if a judge didn't even ask to hear, if the district attorney from Worcester County came in and said, I want you to move 51 people, here they are, and I want you to move them to Hampden. Wouldn't it be a bit extraordinary if the sheriff of Hampden County wasn't given notice?
I think that certainly it would be a better practice to give notice to the sheriff, but the statute doesn't require it. And again,
I'm
what
not sure that the
here,
statute doesn't require it. The fact that the statute doesn't address it specifically, maybe the legislature thought it's absolutely implicit that when you're ordering relief against somebody, right? This is relief against the sheriff of Hampden County in my hypothetical, that you give that person notice?
Yes, Your Honor, and I just acknowledge that it would be a better practice to do that. But in this case...
No, you just said to me the statute doesn't require it. Who pays for the transportation costs, by the way? Once these persons are awaiting trial.
The cost of the removals and of supporting the person continues to be paid by the county, in this case, Worcester County Jail.
But who provides the cars to transport the prisoners?
I believe that when they're held in the Department of Correction, that the Department of Correction transports them.
Now, these pretrial detainees are not necessarily limited to pretrial detainees who are under indictment in the Superior Court. This could happen as a result of a bail review of a district court case, couldn't it?
As long as the detainee has prior
So if every
prison
Superior
time.
Court judge in the county, in the state, he was hearing these cases and was assigning pretrial detainees from district courts and Superior Courts all over the state, the commissioner would need 360 cars to transport people all over the place.
Yes, but again, Your Honor, these are all considerations that a judge could take into account when determining whether to issue the order.
But he could issue it anyway.
It could be issued because the legislature has said that it may be issued. I mean, the legislature has authorized the judge to issue the order, and then whether or not the judge decides to exercise that discretion is up to the judge upon hearing evidence of things like that.
Could I ask, I mean, as I understand it now, what is driving this and what lies behind this whole problem is issues of overcrowding. But at the time these provisions were put in, wasn't part of this about the need to separate certain inmates, co-defendants,
Yes.
or a defendant from a potential cooperating witness? It was about those kinds of security concerns.
Yes, Your Honor. When the statute was enacted in 1943...
So we're taking something that was about those kinds of security concerns and now trying to use it to juggle the problem of overcrowding.
Yes,
We
but
do have
certainly...
sort of a misfit here.
Yeah, but
Yes.
this certainly is not the first time it's been used for that purpose. As I said, in Middlesex and Suffolk counties, it's actually been used for decades for that purpose.
Where there was overcrowding as part of overcrowding litigation.
In those circumstances, there were civil action lawsuits filed.
And the department was made a party, and they were ordered by the court to take the prisoners.
Yes, in one case was a federal lawsuit in which it seems that the department was originally a party, and the second was a state lawsuit in which the sheriff asked that the commissioner be joined.
And was joined.
And he was.
And so was ordered by the court to take the prisoners.
Was ordered by the court under 52A to take the prisoners.
Under 52A.
The
Yes.
federal court certainly wasn't operating under 52A.
Not under the federal court, but in the state court case, which is Richardson, cited in both of our briefs, the orders were made under 52A, but it was in the context of class action litigation.
Ms. Zarmo, can I just go back to one thing? What Judge Can seems to have said is, I don't have to give notice to the commissioner. I'm quite concerned about the position taken here, because this is an administrative action.
I'm not sure where, if Your Honor could point
Footnote 2.
me to where he says that.
Well, it's page 2, footnote 2. He says, in essence, he's saying, well, the commissioner can go file a declaratory judgment action. I understand that, but I am concerned with an assertion that even if, for example, we go to what we appear to be in agreement on, namely a judge can order a transfer from one county to another county house of correction, the notion that you can issue the order without having any understanding of what the conditions are in the second county seemed to me to be extraordinary.
Your Honor, I actually don't read that footnote as meaning that the judge is saying that the commissioner was not entitled to receive notice. I believe that what the judge is saying, that had this arisen in a different context, like civil action litigation, the commissioner would likely have been a party to the litigation, but not that there was no need to give the commissioner notice. And certainly here, when the commissioner called, the judge immediately granted a hearing. We had a hearing that very day on the motion to vacate, and then...
But the commissioner has an order that she must obey. In this particular case, the commissioner came into court and the hearing was granted. But if the judge believes that there's no need to hear from the other side, and again, looking at paragraph 2, he's not talking about the impact. He says, I've heard from both sides, but I just know that in Worcester County, I just know that in Worcester County, it's a critical mess.
Yes, Your Honor, and certainly it was open to the commissioner during the motion to vacate to present evidentiary support, and the commissioner did file several different affidavits attached to the initial motion to vacate and subsequent supplemental memoranda, and then the motions for reconsideration concerning issues of overcrowding and other issues pertaining to the Department of Correction.
Thank you, Ms. Lozamo. We'll take a short break.
Thank you.
All rise.